Okay, so here's the deal. We're doing a video. It's a good video. We are going to be talking about something important that I think you should really pay attention to. Some individuals are getting quite spicy because the wait times are not so over the rainbow amazing. They are not riding a unicorn into the sunset on an Indiana Jones film set. Awesome. And what happens is people get very cranky because they can't work. They know they're disabled. And they're in this situation where they're running out of money, running out of friends to borrow from, and they're pissed. I just want to remind you guys that taking that anger out on SSA employees, which is where you call up, an SSA employee, or you go to one of their field offices, or you see an investigator, watching you. I just want to give you some basic things. If you do give them some spiciness, here are some of the things that can happen to you as a result of that spiciness. Now, I want everybody to kind of wake up. Let me get some buttons here and just kind of focus because this is important. All right, here we go. You can have number one, and this has happened to a whole handful of my claimants, immediate removal from the SSA office. That's 41 CFR section 102-74.39E-400. That's basically because you were not acting like you should inside an SSA office. Okay. Another one is denial of in-person SSA services going forward, or restricted to remote contact where you have to call in. That's basically the same gig, same operational policy, same CFR, 41 CFR. Some of you do such horrible things, and I've had a handful of these, that basically you get banned from the Social Security Administration facilities. Could be one, could be all. Had quite a few of these, okay? 18 U.S.C. section 1382, if you're wondering and wanting to read up specifically on that. Now, let's say that basically you do something and it's at the point where they have to do an incident report to management, and usually the Office of Inspector General, which again, I've had a handful of those. POMS GN 03360.005 is the reporting of the threat, okay? That's part of the Inspector General Act of 1978. So when you guys go at it or really get spicy, they usually refer you to the Office of Inspector General, and then you are on a hot list for being investigated as a potential or current recipient. Next one, you might get investigated by the Federal Protective Services, FPS, or the police. Again, I've had a couple of those, right? I mean, I've literally had it where I've been at a hearing office, showed up for the hearing, my claimant showed up for the hearing because it was a death threat to the administrative law judge, the ALJ, and we had the regular police there, we had the special agents on behalf of the federal government there, we had lots of law enforcement. There's all kinds of law enforcement that shows up. I was actually surprised. The federal ones were, to be fair, a little bit better trained than the state guys were. Definitely knew their code and law a little bit faster. But the bottom line is they bring all kinds of individuals out. But just to be fair, if you ever make a death threat to an SSA employee or an investigator, if you're applying for benefits, you are not getting them on that round. I have never seen somebody get them on that round. You have to reapply with a totally new claim to even have a shot. Okay. Next one, arrest for assaulting or impeding an SSA employee. That's an important one. Basically, by the way, the Federal Protective Services, 40 U.S.C. section 1315. But this one, where you get arrested for potentially impeding their abilities or assaulting them, that's 18 U.S.C. section 111, 18 to 20 years, depending on what you do. And also, just to be clear, if you guys are wondering if you should stick around for this video, and please if you enjoy these videos, I have the official handbook details from a FOIA request as to the class levels, class 1 through 3, 1 being the worst, of what examples are of bad things that people do and what will happen to you. So I'm going to tell you in this video, and I have a document that most people don't have access to. It is generally available, but it is a bitch to find. All right, next one.
If you are charged for making threats in person, mail, phone, email, 18 U.S.C. Section 115 or 18 U.S.C. Section 875-876 for threatening communications. You do that stuff, they're going to open up investigations into you. Prosecution for obstruction or intimidation, check out 18 U.S.C. Section 1503, which is obstruction of justice, and Section 1512, witnessing potential tampering. You mess up something at their station that's going to slow them down, you grab their computer, you grab something around them, it's a problem. Next one, criminal fines and restitution. 18 U.S.C. Section 3571, fines. Section 36638, mandatory restitution in some cases. Court issued restraining orders or injunctions against you. They can even do those. 18 U.S.C. Section 1514. Now, keep in mind, if what you do really upsets the SSA person, that SSA person, right, if it's up there, they can go ahead and claim a civil lawsuit for damages against you for torts, for something like emotional distress that occurred as a result of you. They can even do basic, personal suits if it threatens them or is even outside of the scope of federal duties that they would normally do in a personal scope. Okay. You don't show up, contempt of court, 18 U.S.C. Section 401. The court can even order you, demand you, require you in your life's existence to do certain programs, 18 U.S.C. Section 3563B, such as anger management or like counseling or community service, or potentially prison or jail time. That happens. Now, if you're an employee working at the SSA and you do it to another employee, that's 5 CFR Part 2635, which is Federal Employee Conduct Standards, which they go after them. And then, of course, if it's an immigration situation, they can, get you out, remove you as a citizen, remove your ability to get benefits, 8 U.S.C. Section 1227A2. Now, over here, I have directly from the handbook, which I printed out, specifically about the different class levels of the level of shit starting you do and what will happen as a result of that. Now, some of you are thinking you would never do this. You got to understand, we're post-Bidenomics. People don't have money. Things are really bad. Food is obnoxiously expensive. And pretty much people are waking up to the reality that every time you ask the government for something, it ends up costing you vastly more, and you're pretty pissed off at the end of it. So, it's just one of those gigs where the more we ask of the government, the more we don't really seem to end up in the driver's seat. We seem to end up like left behind trying to catch up and not having enough money. That seems to be where we end up. I gotta be honest with you guys. Like, yeah, the private industry of investors and all that kind of stuff, yeah, they've done bad stuff, but I don't think the US government has a squeaky clean, a dirty, a rancid, whatever's after that is, I think, more the type of record that is kept by the actions committed by the government. I think we're, you know what I mean? Like when people are like, well, you can only trust the government with your money. I'm just like, that is like a step before communism. I'm not sure you understand what you're really getting at. I'm not sure you fully comprehend the level of mental restriction you must be interacting with inside your head. All right, here we go. 004.180, reprisals against SSA employees. Any employee who believes that he or she has been threatened with a personal action or any other action, or who has been harassed or harmed by any action as a reprisal for having made a complaint or provided information to the OIG, may request the OIG to review his or her complaint. So, if somebody reports something about you or they find something in your record and they send it to OIG and then you get pissed off at them, and there's a potential of a reprisal situation, an OIG can go ahead and do their investigation. If OIG-OI has reason to believe that the reprisal complaint may have merit, it may, depending on the circumstances, decide to conduct an investigation or refer the matter to another entity for investigation. If OIG refers the matter to another entity for investigation, the referral will be to the
the SSA Deputy Commissioner for Human Resources, or the Office of Special Counsel. An employee may also file a complaint directly with the OSC. The OSC has the ability to seek a stay of an agency personnel action from the Merit Systems Protection Board. So in other words, if they want to complain about you, there's a method and a way they can do it. All right, 004.190. Investigations of threats and assaults against SSA employees. Section A, the safety of all SSA personnel and facilities is of paramount concern to the Office of the Inspector General. Okay, next one. The role of the OIG in matters related to the safety of SSA personnel and facilities is found under USC 1320A-8B. This law imposes criminal penalties for attempting to interfere either by force or by threat of force with the administration of the Social Security Act. So if you call up the SSA and make some statements, they can go after you with criminal action, okay? Not criminal action committed by them, but legal responses of, potential claims against you for criminal actions you may have committed. The statute makes it a crime to attempt to intimidate or impede, which means corrupt or by force of threats of force. Okay, so you're basically trying to get them to do something by threatening them. Any office, employee, or contractor of the Social Security Administration acting in official capacity to carry out a duty under the Social Security Act, or to otherwise obstruct or impede or attempt to obstruct or impede the administration of the Social Security Act. This may include threats against their family. And remember, this kind of stuff happens, and I want to go through how this happens. They have you go and meet at like a desk, reception, where usually there's no personal stuff for the most part, because these SSA employees know that a lot of you guys need your benefits, and without your benefits, you go homeless. You can't eat, you can't do stuff. So the stakes are high, and the last thing they want you to do is figure something out about who's in their inner circle, because you might be the thing that is a nightmare to them. Maximum penalty for conviction of use of force is a fine of $5,000 and or 3 years. Imprisonment. The maximum penalty for conviction of a threat of force, but not the use of force, is a $3,000 fine and or 1 year's imprisonment. Okay, in subsection B below, procedures for the receipt of allegations or threats and assaults against all covered employees, contractors, and facilities, as well as for the actions that OI agents and the SSA managers are expected to take when threats or assaults are reported, are set forth. These instructions are intended to create a uniform OIG policy pertaining to these time-sensitive allegations and investigations. In other words, if you do something, the SSA wants to look like they're on top of it. And I'm going to be very honest with you. They're on top of it that day. Like the agents, the police, the sheriffs show up that day quickly. The procedures enhance OIG's ability to analyze and respond to these types of allegations/investigations. Procedures. OI shares the responsibility for investigating reports of threats of force or use of force against SSA employees with the Department of Homeland Security Federal Protection Services, FPS, which has jurisdiction over physical property owned or leased by the federal government, to include jurisdiction over threats of force and use of force that take place on federal property, and with local law enforcement in the activity if the activity occurred off of federally owned or leased property. OI field divisions receive allegations of threats from various sources. Generally, threats of force or use of force should be handled by the first law enforcement agency to respond to the threat, whether that is OI, Federal Protective Services, local law enforcement, or other law enforcement agencies having jurisdiction. And just from experience, because I've been in these situations, I've been in a lot of weird situations with this stuff, but I've also represented a lot of impoverished, mentally totally unsound people. Usually at least two groups will show up. The primary objective is to stop the threat of force or use of force. As soon as possible, all incidents of threats must be entered as an allegation into NICMS, and the appropriate threat incident category level must be reported to OI headquarters. Selected. It must be reported to OI headquarters through the Assignment Criminal Investigation Division, CID desk, officer by email or telephone within 1 hour of being notified of the situation. Upon receipt of a threat allegation, the decision to conduct an investigation and procedures to follow will be based on the seriousness and sensitivity of the incident, as defined by the following threat categories. All right, there's 3 threat level categories. I'm going to give you 3 so you get the lower level one. Then we're going to go all the way up to 1, which is the, you effed up. You effed up. You know what I mean? All right. Category 3 incidents. Incidents designated as Category 3 involve situations that may be harassing in nature toward an SSA employee, contractor, or official. However, they do not cause any impact or direct effect on the normal operation of the SSA. All reported Category 3 incidents must be recorded in NICMS as an allegation similar to Cat 2 allegations. OI supervisors will assess the nature and circumstances surrounding the incident in order to determine whether the allegation warrants further OI action. Okay? So in other words, that's the little one. You say something really mean. You say something really bad. You harass them a bit. Category 3. Category 2 now. Category 2. Definition. Incidents designated as Category 2 involve non-imminent or less specific threats against SSA employees, contractors, and/or facilities. This category covers instances of conditional written or verbal statements directed against an SSA employee, contractor, or facility about a potential future action or event, such as bomb threats that are vague in nature, such as an anonymous caller states there's a bomb at the SSA, yet no additional information is provided. Okay? Threats made by individuals who lack the apparent physical ability to carry out the stated threat are also included in this category. All reported Category 2 incidents require an OI allegation number. When an OI office receives an allegation involving this type of incident, the matter must be recorded in NICMS and developed for investigative merit. OI supervisors will assess the nature and circumstances surrounding the incident in order to determine whether the allegation warrants an investigation. So that's your middle category. That's your middle one. Now we're going to the UF'd up category. Like you blew it. Like your benefits are there's a problem. You're probably not gonna have benefits if you did these things, right? You could be going to jail. You could be going to prison. Okay. All right. Definition: designated as a Category 1 involve direct and imminent threats or occurrences of physical assault or endangerment against specific SSA employees and their families, contractors, and/or facilities. Examples include an assault or threat to do bodily harm to an employee, white powder mailings, bomb threats where a specific target is mentioned, in other words, the Dallas Regional Commissioner's Office, or other incidents which may impede or disrupt SSA operations or cause SSA to deviate from normal operations, like people have to leave the building, stuff like that. In addition, any other incident designated sensitive by the Assistant Inspector General for Investigations, the AIGI, in other words, threats against the Inspector General, special agents, or the Commissioner of the Social Security Administration will be treated as a Cat 1 threat. So you make little threats against the big guys, the executives of the SSA, Category 1 assessment. All reported Category 1 incidents require OI to open an investigation under an OI case number, regardless of whether or not another law enforcement agency, FPS, potentially is also involved. So no matter what, you are going to be investigated. You're probably going to have to face some sort of charge. You're probably going to lose your benefits in some way for some period of time. Okay. Additionally, within 24 hours, a special agent in charge or his or her designee will submit a Category 1 threat notification report form, OI 95, to OI headquarters via their assigned CID desk officer with a CC to the SAC and ASAC of CID. This report will serve as a formal notification of a follow-up to the initial 1 hour required notification, the report should contain as much pertinent information as possible based upon what is known to OI at the particular time. So category 1, you screwed up big. You made real threats with details, or you made smaller threats to the executives of the SSA. Okay, next thing you need to know. Note, for any incidences that occur, contract guards using force that do not clearly fall within one of these 3 categories above, a determination will be made in conjunction with OI headquarters as to the appropriate category and or course of action at the time of the notification. In responding to allegations of threats or assaults, OI field division personnel will respond to the scene. Responding to the scene of a Cat 1 incident is mandatory. They're going to show up. They're going to have all of their gear on. They're going to be tactical. Okay. I'm telling you, I've been a part of these things. I've seen these things. Okay. So it's instance mandatory unless otherwise directed by the AIGI or the DAIGI after discussion with the SAC. I've never seen them not do it. I've always seen them show up related to it. Okay. All right. SACs or their designee will determine if response is required for Cat 2 and Cat 3 incidences. I'm going to tell you something too. One thing that this pops up, and I don't know if you guys know this, but the judges, they worry because they got to leave the hearing office, the big building. So they'll usually park through a side door or back door or whatever door. And so if they know that there's a problem or there was recently a problem, those judges will usually have somebody go out and look around and see what's going on, and then they'll leave. Okay. All right. So they'll respond to the scene, then coordinate with an initial responder, FPS, local law enforcement, as well as the appropriate SSA officials regarding an investigative action plan to include the preservation of any evidence, follow-up interviews, etc. Next one, notify OI headquarters as outlined paragraph B of this section, query appropriate databases for additional background information on the subject, then obtain all readily available information from SSA to include, and then these sections were blocked out. These were not allowed to be utilized. This was blocked out under their Freedom of Information Act, where they wouldn't give that information. Next section, obtain copies of all reports issued by other investigative agencies and upload them into NICMS upon receipt. And then basically complete a threat assault interview worksheet, Exhibit 4-16, which is available with optional items for consideration when conducting these types of investigations. When conducting threat investigations, OI will not promise protection to any SSA employee or their family members unless specifically instructed to do so by the AIGI or his or her designee. So basically, if one of these employees goes through one of this, they are directed not to let that employee know that they are going to be protected and under the protection of these individuals unless unless the authority figure. Let me read to you the specific line. It is late. My brain's starting to fail a little bit. Unless AIGI or his designee specifically instruct to do so, that they'll basically say, hey, we will protect you, the employee, and your family members. All right. This is me reading you a bit of the Riot Act so that you specifically understand how this stuff works. Because at the end of the day, I have seen this a handful of times, the whole schmutz, the whole thing. As a result of this, people are getting more aggressive and angry with the SSA because they don't feel like it's moving in the direction they want it to. For this reason, you now know that you should be courteous. Excuse me. Courteous. There's a lot of dust in this room. Courteous and nice to the SSA personnel because they reserve the right to go ahead and begin this shit show of a process to get you investigated, which you don't want. I mean, if it's bad enough, you go to jail that day. Is what it is. All right. With that said, you have a wonderful night. Please remember to like and subscribe. I will catch you a little bit later. Hit that like button. Don't be afraid to hit it. Also, if you have a big question, please remember 30-minute or 1-hour private consultations are below. If you need a Social Security disability attorney, howdy, Attorney Walter Hnot, the most viewed, subscribed to, and clicked on disability attorney in America. With that said, please remember I go live on Mondays and Thursdays to answer questions for free. You get like 5 to 7 minutes, one question, maybe two. use a fake name, have your legal question ready. Other than that, please remember to hit that like button. I'll catch you all a little bit later. You have a wonderful night, and we will go from there. Thank you so much, Attorney Walter Hnot. Bye-bye, everybody. Bye-bye.